Let's go ahead and bring in our guest for this hour to discuss. Joining us now from Santa Fe, New Mexico, criminal defense attorney John Day. John, thank you for being with us. Happy Friday to you. Okay, John, how do you think this cross-examination is going? Defense counsel is really trying to get the medical examiner to talk about he had cocaine in his system, he had alcohol in his system, he was, acting erratic. What's your takeaway? How is the cross going?
Well, thanks for having me. I think the cross, the defense lawyer is doing what he has to do. I kind of like this witness, this medical examiner. He seems pretty unflappable. But what the defense attorney has to do is try to plant in at least 1, 2, 3 jurors' minds the idea that that this was backing up the self-defense claim, backing up the idea that there was no other choice, that this woman felt so cornered and so threatened that this was a reasonable response, even if in hindsight it doesn't look reasonable. So, the medical examiner, these guys, they testify so often. They're so good on the stand usually, and it's hard to get them to look like they don't know what they're talking about. They're not aware of this stuff. They're really good at this, and I like this guy in particular because he comes across as very approachable. I think jurors are going to relate to him. He's a scientist, but he doesn't talk like a scientist. And of course, all these jurors have seen all the CSI shows on TV, and they know that the scientific evidence is coming in. They're interested in it. This is not like a high school science class where they're bored, they're rolling their eyes. This is stuff that's relatable to them, especially in the context of what they've been hearing in this trial. So I think the defense lawyer is doing what he has to do. Whether it's going to get anything across to the jury remains to be seen.
And John, what about the fact that defense counsel was asking there and basically indicating, this isn't a shot, he didn't say these words, but basically he was suggesting this wasn't a shot to the head, this wasn't a shot to the chest, talking about the path of the bullet here. And again, trying to go along with his theory that she did this in self-defense.
Yeah, it's significant. I mean, they want the jurors to think if this was some type of non-self-defense situation, why isn't there a shot to the mass of the chest or to the head or something else? I mean, it's consistent with their theory of self-defense in that the placement of the shot is so random, and it gives you the sense, at least they're going to argue in closing, that she was acting out of fear, she was acting out of feeling like she was going to get hurt, that she had some reason to respond the way she did, and it was reasonable. So, yeah, I mean, that goes to the point that it was self-defense. This was not a shot to the chest, shot to the stomach, shot to the head. This was something, in their view, that's consistent with her being really terrified and really scared.
Yeah, good point, John. Okay, more cross-examination is going to continue after a short break. We'll be back. Let's go ahead and bring in criminal defense attorney John Day. Okay, John, that was a little bit startling from defense counsel there, but I mean, he was trying to make a point.
Yeah, the judge is letting the hypotheticals go. She's giving them pretty free rein. And what the defense simply wants is this witness, words coming out of his mouth that say to the jury, yeah, I mean, this is feasible. This could have happened this way. It's possible. I can't tell you. The medical examiners, of course, they cannot give the final opinion on who did what and what happened and at that moment. But what they can do is they can provide the jury with basic information, with building blocks to get them there. And then in the eyes of the defense team, they just wanted this medical examiner to say, yeah, your hypothetical could work. I don't know what really happened, but all they need is to land that one punch with this witness. So they're hoping that at least one or more of these jurors is going to remember that exchange and say, well, it could have happened that way. And is that reasonable doubt? And in closing, they're going to hammer on that. But it was an interesting exchange. The defense lawyer getting very emphatic there, and whether that helped his case or not, who knows?
Yeah. John, the defendant here had said that this was kind of a stand your ground situation. They had filed that motion. The judge ended up denying it. They wanted this murder charge dropped. Of course, that didn't happen. That's why we're here today having the trial. One of the things that the judge cited was some of the ring camera footage. We've had that up before for our viewers, in which they're saying that the defendant in this case, after the shooting, just appeared calm and kind of in a joking manner. So the jury is going to see and has seen a lot of the video that was available. We're taking a look at some of it right now. How do you think that's going to be?
Well, you know, two sides of the same coin. The defense is going to say, look, when something like this happens, people react different ways. There's not one predictable pattern that you're supposed to react this way. Of course, prosecution is saying, you know, this is clear that this is someone who was not acting out of fear, but they were acting out of intent, malicious intent, murderous intent. Whether the jurors buy the defense theory that you cannot say with certainty that someone who is supposedly acting in self-defense is supposed to act this way, and she didn't act the way that you think she was supposed to act. You know, they've got to differentiate that. They've got to put in the minds of this jury what took place. And again, each juror is going to be looking at this thinking whether or not, you know, they're supposed to relate their own lives to it. They're going to be thinking, how would I have reacted if I had to act in self-defense? What would I have done? Is this consistent with human nature and things that I've seen in my life? So, you know, the defense is certainly hoping that the jurors are going to say, I can't say how I would react, but this is how this person reacted, and we can't discount that.
John, thank you. Coming up next, we have a witness. It's a sergeant who extracted the defendant's cell phone. We'll be back.